I'm Linda Pistner. I'm the Chief Deputy with the Office of the Attorney General, and I am the Attorney General's designee on the Citizen Trade Policy Commission. What I'm going to try to do is just very briefly sketch out to you sort of the issues involved with trade treaties. It's a vast subject. It's a horrible thing to have to take up at 9 o'clock in the morning. And then let you ask your questions, because I think that's probably more efficient than my talking for a long time. And in doing that, I'll try to let you know what the issues might be that you would be looking at if you were to include this in some sort of a study. The first question everybody asks is, why are we even worried about trade treaties? Because they're obviously a function of the federal government to negotiate. And the simple answer to that is that more and more treaty negotiation and treaty enforcement are focusing on the ways in which what they call non-tariff barriers, which is a fancy way of saying regulatory requirements, impede trade. So that can be regulation at the federal or state or even at the municipal level. Part of the reason why it's not simple to answer how do the treaties affect water is you have a grid of treaties out there, everything from the individual country treaties we negotiate one by one. U.S. Australia is an example. There are regional treaties like NAFTA that most people are somewhat familiar with. And then there are massive treaties under the World Trade Organization to which about 140 plus countries belong. The other reason we can't simply identify how they impact things is because they're enforced in a different way than we're used to. We're used to going to court, you get a judicial decision that creates a precedent. Under the treaties, they all go to arbitration. They're individual decisions. They're not a precedent for the next case. If a rule of a statute of the state of Maine were to be challenged under a treaty, it wouldn't even be defended by the state of Maine. It would be defended by the U.S. Department of State at the expense of the state of Maine in significant part, but by the State Department. And I have to say they've done a tremendous job in defending some of the cases that have been brought. So you have rules that are different from what we're used to looking at. You have a different enforcement mechanism. And it's not necessarily oriented the same way our courts are, because arbitrators are private experts in trade. And so we know trade is good. We're not against trade. The problem is, predicting what are the consequences of treaties as they apply in particular situations. What are some of the rules that are involved in trade? Well, under the so-called GATS, which you may have heard of, this is another federal area ripe with acronyms, the General Agreement on Trade and Services. There are restrictions on participating countries' ability to limit access to markets. Now, that could arise in a variety of ways. If you say stores can't be larger than a certain square footage, that's something that might be challenged under such a requirement by a participating country who's trying to do development somewhere where they're being prohibited from doing that. Quotas are also prohibited, and somewhat to the surprise of the United States, banning something can be viewed as a quota of 0. So the U.S. got a bad surprise in a case that was brought by the tiny country of Antigua, although bankrolled by Great Britain and other countries that had substantial investment in the gambling industry, to challenge the ban on internet gambling at the federal level in this country. Now, start with the fact that the United States did not even think that we had agreed to be subject to the GATS with respect to gambling. You have to go service by service, product by product when you're negotiating to decide what the scope of a treaty is. And the challenge was brought under our agreement to have entertainment services covered by the treaty. Well, because of all the public policy behind regulating and restricting, in many respects, gambling, the United States did not believe that gambling was covered. An arbitrator initially disagreed with that, and then said, well, you've got, this ban is the equivalent of a quota of 0, so you're violating the treaty. So then what happens? The the country has to either agree to commit, as they call it, gambling to the coverage of the treaty, or negotiate some other service that somebody wants to have covered by the treaty as compensation for that. So you have to look specifically at the service or the product that you're talking about to even start to figure out what treaties might apply to that. Another issue that has received some attention, and I think what you're focusing on here, is some, certainly by no means all, of the treaties have provisions that allow private investors to bring challenges under the treaty. Most challenges are brought country to country, which is why we're defended by the U.S. State Department. So the country of Antigua brought a challenge against the U.S. in the gambling case. But NAFTA allows for private investors to bring a challenge, and the argument there is typically you have expropriated my investment in your country, and therefore you owe me damages. And it's essentially the same as the sort of takings analysis that that you in this committee are more familiar with seeing when discussions arise about the impact of regulation on private property. So a success story in California, they passed a ban on the additive I always get this backwards, MTBE or MBTE, one of those. Okay. And the company, the Canadian company that manufactures it said, you know, that's violating NAFTA. And after long litigation that I believe cost something in the neighborhood of about $6 million, the arbitrators said, no, that's not a violation of NAFTA because of the health and safety issue. And I'm vastly oversimplifying here in order to not put you to sleep, but that was a success. On the other hand, in the Metalclad case, which arose a challenge against Mexico, the company had bought land where they were planning to build a landfill. It turned out that it was over an aquifer that once the plan of the landfill became known, and this is often the way I think that regulation gets fine-tuned. We may think we've set a rule based on what we know in general, and then a specific project will come along that raises issues that people hadn't thought about at the time they set the general rule. So in our democratic system, we go back and relook at that. And sometimes that can be messy, particularly at the municipal level. That can get messy. People get upset and they come in and talk about what the problem is, and then we try to look at legally what can be done at this point. In doing that, you might engage in activity that an arbiter would later find to be discriminatory against a foreign country and their investment. So those are the risks that can be out there in terms of, you know, your efforts to engage in regulation. I don't think it's possible ever to really totally pin down, you know, what the potential issues might be, all the treaties that might apply, the service that you're talking about here. Bulk water transfers are covered by some treaties, wastewater treatment's covered by others. Water itself as a natural resource, for example, is not covered by the GATS, but massive, you know, larger extractions could be covered by them, and there are a few decisions to go by in terms of interpreting. What I, as a lawyer for the state, would like to have been thinking a lot about and talking with people about is what ways can we recommend to state and local legislators that they protect against challenges in the future. There are some obvious answers to that. One is that as rules continue to be negotiated under the GATS, for example, the focus is on transparency so that people will know when they come and make an investment in your country what exactly the impact of your regulatory system is going to be on them. And I think we're in an era where everybody thinks transparency is a good thing. The question is, does it extend to, for example, do you have to put people on notice of your court decisions, of your administrative interpretations that may not be written down? So there are a lot of gray areas, but that is one thing that we can do, behaving in a way that eliminates discrimination, particularly against other states or countries is another one. But those are the kinds of issues that you would be looking at if you included this provision and ended up deciding on a study here. I know that everyone is concerned about money. And so some studies that people would like to do have not gone forward because of finance. And late last night I had an email from a nonprofit organization that the Trade Policy Commission works with, the Forum on Democracy and Trade, and they were suggesting that if we were going to do this kind of study here in Maine, that there might be some money available to support that, because you really do need some experts. I sound like I know this stuff talking for 5 minutes, but I couldn't do it. So I'm happy to take your questions if I could answer them.